When you get a DUI, there will absolutely be some restrictions imposed upon your driver's license. These restrictions are imposed by the Secretary of State, and what happens to your license depends on the charge made against you and the charge that's ultimately negotiated on your behalf. Of course, there will be no penalties if your charge is thrown out of court, but that only happens in a minority of cases. So for most people, getting a DUI means preparing to deal with some kind of consequence to your driver's license. A first offense DUI, for example, typically involves a 90-day restriction of your driving privileges if your lawyer successfully plea bargains the charge down for you. A high BAC theoretically means you'll be on an ignition interlock and driving on a restricted license for 10.5 months. Restrictions are imposed in all cases. The court has no authority to modify them. So if a person, for example, says, well, gee, I'm planning a trip to Florida and I was driving down, sorry, you can't be helped. The judge has no jurisdiction to change or modify, shorten or lengthen any term of suspension or restriction. Whatever you wind up with is basically put into a grid, and the Secretary of State says, if A, then B. If it's an impaired, 90 days restriction. For an OWI, 6 months restriction. High BAC, 1 year restriction. Second offense drunk driving, license revocation. So license restrictions depend entirely on the final outcome of your DUI case, which makes it important then to make sure that your lawyer does the best he or she can for you.